I'm now delighted to introduce our first speaker, well known to many of you, Professor Tony Holland. Professor Holland trained in medicine at University College and University College Hospital, London, qualifying in 1973. After some years in general medicine, he trained in psychiatry at the Maudsley Hospital and Institute of Psychiatry in London. From 1992 to 2002, he held a university lecturer's post in the section of developmental psychiatry in the University of Cambridge, and in 2002 was awarded the Health Foundation Chair in Learning Disability, establishing the Cambridge Intellectual and Developmental Disabilities Research Group. This multidisciplinary group undertakes a broad range of research relevant to people with intellectual disabilities. His specific interests include the eating, behavioural and mental health problems associated with Prader-Willi syndrome, and also the clinical and legal issues relevant to the needs of people with intellectual disabilities. In 2010, he was elected a Fellow of the Academy of Medical Sciences and was awarded a CBE by the Queen in 2015. Professor Tony Holland is also President of the International Prader-Willi Syndrome Association and patron of our association. I am delighted to welcome Professor Tony Holland.
Thank you, Susan, for a very nice introduction. And as always, it's a great pleasure to be here. The first challenge of any talk these days is to share your screen. So I'm now going to do that because this is where things can be a little dodgy, but I'm going to try and do that.
No problem, Tony. I can talk you through it if necessary. Yeah, that's worked lovely. If you could just go on to the normal view. You know what you're doing. Look, I'm telling you, you don't even need me. Perfect. We can all see that. Thank you.
You can see that. Okay, good.
Yeah, well, beautiful. Again, thank you.
Just to say, it's a real pleasure to do this. And I think one of the interesting things is that the issue of mental capacity keeps coming back. And, you know, I've talked about the Mental Capacity Act when it first came in all those years ago, and have talked about it intermittently over the years. And I think what we find is that the challenges of putting it into practice remain. And although there has been case law and other developments that help us think about this, it's still not easy. And it's not easy, not, I think, because the legislation is poor. I personally think the legislation is good. It's not easy because it really taps into some very fundamental challenges when supporting people who are vulnerable for whatever reason. They may be vulnerable to ill health. They may be vulnerable because of their behavior. And you're trying to balance all the time, respecting rights and choices on the one hand, and risks and managing risks on the other. Now, in my talk today, I will tend to focus on impairments, and that often is the case in such talks. But I just want to stress right at the beginning that, of course, people with Prader-Willi syndrome have great strengths as well. And we need to acknowledge that. And particularly in this field, we need to understand that part of the skill of good social care and of family support is how you build upon someone's strengths and help to mitigate against the difficulties that arise because of perhaps cognitive impairments or whatever it happens to be. What I want to therefore do, and I want this to be an interactive session in a way, because it's nearly an hour and a half, and that's far too long for you to have to listen to me. So I've broken it into 3 parts. And by the way, I called it Making Sense of Mental Capacity. It's going to be for you to judge whether I do make sense of mental capacity or not. But this is what I thought we'd do, is we'd first of all reflect a bit about what is it about having Prader-Willi syndrome that impacts on a person's decision-making capacity and their ability to act in accordance with what in the past they may say are their wishes and values. They want a good life, they want to remain healthy and so on. Yet someone with Prader-Willi syndrome may act in a way that is contrary to that. And then they will pause and have questions and discussion, and then come to the little more detail about the Mental Capacity Act. Most of you will be very familiar with it, so I'm not going to spend long about that, but just trying to pick up on some of the key issues around the Mental Capacity Act. And then finally putting the Mental Capacity Act into practice. and addressing issues of who makes decisions, and several other issues that have arisen, I think, over the years with respect to it. Now, I think that James Coding is here. Am I right, Patsy? I think he might be attending, but maybe not. I hope he is, because James...
Sorry, unfortunately, he isn't able to join us this morning, but he did wish you the best of luck.
Okay, well, then there won't be anyone to tell me when I've got it wrong, because James is a real expert on these things, but hopefully we'll be fine. So the first part of my talk is about really asking this question: what is it about having Prader-Willi syndrome that impacts on someone's ability to make decisions and so on? And I'm going to start with just a summary of one of the people that I used to see with Prader-Willi syndrome when I was working in clinical practice. Now, here's someone who presented with many challenges. And of course, most people with Prader-Willi syndrome do not present with this degree of challenge. But in some ways, what he does within one person here illustrates some of the real challenges that may occur across the whole population of people with Prader-Willi syndrome, but perhaps to lesser degree, or perhaps there's only one challenge in one person, but a different one with someone else. First of all, that his behavior and his choices in life had led to many different residential placements, to excessive weight gain because of situations where he refused to agree to food security, and placement breakdowns because of aggression and at times self-injurious behavior, and behavior that put him into positions where he was at risk of being exploited and so on. And these things will be very familiar to the Prader-Willi Syndrome Association. And it can be very difficult to manage such situations, but right at the heart of this is issues of choice, and the right someone has to make choices, and the right that others might have to override such choices in order to protect someone from harm. Now, recently, Elizabeth Fistine and colleagues have published a review of case law published from English-speaking jurisdictions, so America, UK, Canada, Australia, for example, that have actually specifically touched on Prader-Willi syndrome. And here again, what Elizabeth identified was this tension between how we balance respect for rights of people with Prader-Willi syndrome with the provision of good care. And these cases that she identified, published in the legal literature, illustrated how disagreements had arisen or whatever that had resulted in harm. And in this one case of Travis McHone, tragically in his death, and he had left his group home and had walked along a motorway, and eventually, despite efforts of the staff to try and manage this, had been hit and he died. Now, again, this is obviously an extreme example, but what all these cases that Elizabeth identified really tap into, again, is this tension. How do we manage and address issues relating to choice versus protection from harm? So this first part of the talk is focusing on factors that both contribute to risk, but also impair capacity. Of course, if someone with Prader-Willi syndrome behaved in a way that didn't cause problems, we wouldn't in a way be having this discussion, because there wouldn't be the need to consider issues around capacity to quite the same degree. And I think it's sometimes the factors that impair someone's capacity that also give rise to the fact that they may behave in ways that put them at risk. They're, in a sense, two sides of the same coin. And as a sort of brief summary, really, I think there are those characteristics associated with Prader-Willi syndrome, such as what I've called the neuropsychiatric phenotype, and I'll come back to this. So this is the hyperphagia, etc. But also, and I think now we're paying more attention to this, there's not only the issue of IQ and the person's IQ, but it's also what are called often higher order cognitive impairments. And again, I will come back to this. And then finally, I think there's the issue of emotional regulation. That I think what we see, particularly in terms of emotional outbursts, is an inability sometimes to control one's emotion in a way that then allows someone to balance the information and make a choice, make an informed choice. But I think it's also really important for all of us to be aware that there are factors in the environment that impact in many ways on both managing risk, but also issues around someone's capacity. There's the presence or not of food security. And of course, the person may not want it, but if it's present, then I think often what it does is lower anxiety, and it may help someone to gain capacity. Whereas if they're living in circumstances where there's no food security, they're so focused on eating and on food that it actually impacts upon their ability to make other decisions. It will depend upon the level and nature of the support available. And it may also depend on, here I've used the language of the Equality Act, reasonable adjustments. To what extent is that environment designed in a way that helps people understand the circumstances? Are they using visual communication systems and so on and so forth? So there's an interaction there really between the person with Prader-Willi syndrome and the particular impairments they may have and the environmental circumstances that they're living in, that both impact upon their behavior or the risk of such behaviors, but may also influence their ability to make decisions with respect to their life and so on. What I've called the neuropsychiatric, or sometimes referred to as the behavioral phenotype of Prader-Willi syndrome, will be very familiar to you. But I list them here because each of them may in some way not only give rise again to the problems that we have to then try and manage, such as the overeating, but also may impair someone's decision-making capacity. And as I think will come up in discussion, this issue of overeating, thinking about food and so on, may be one factor in impairing someone's decision-making capacity, that if all you can think about is food, it may be very hard to reflect on other aspects or to balance choices, because everything is driven by concerns about food and when food will be available and so on. But repetitive and ritualistic behaviors may also mean that you get stuck in a rut, if you like, and it's very difficult to get out of that. And the work of Kate Woodcock has shown that. I've mentioned already the impact of emotional outbursts, but other things may be mood disorders and particularly psychotic illness. And I'll come back to these in a moment. So all these factors may be important. So when we're thinking about the Mental Capacity Act, we're thinking about having to perhaps make decisions on behalf of someone with Prader-Willi syndrome, these factors may all be important to consider in one way or another. It may be different, the emphasis may be different in one person with Prader-Willi syndrome compared to another, or may even vary in the same person over time. I think the issues of the temper outbursts and capacity are really interesting and important ones. And I often use this slide, which was prepared by Kate Woodcock many years ago, showing their thinking about temper outbursts. Now, the reason I show it here is really just, first of all, just to emphasize the fact that the way Kate thinks about it is that you have this problem that arises from impaired brain function, gives rise to difficulty in switching attention, high arousal, and as a result, in the context of some unexpected change, an outburst. The reason I mention it, and I'll come back to this right at the end of the talk, and that is that physiological arousal may further impair someone's decision-making ability. So someone may be perfectly able to make decisions over a particular issue when calm and relaxed and so on. But the moment they start getting upset about something because there's been some unexpected change, and then lose it completely with an outburst, clearly at that time when they're having the outburst, they're not going to be in a position to make decisions or understand or balance whatever it is that's being asked of them. And you could argue that for those minutes or hours or whatever it is, that they may certainly lack capacity. And this has arisen recently in the context of a rather sad and tragic case of someone, a young person who died with who had Prader-Willi syndrome who died. And one of the questions was at certain times when having an outburst, would he have had capacity to make decisions for himself? The other thing just to return to is the issue of mental illness. And I do this because when thinking about capacity, and I'll come back to this, one thinks about the nature of the impairments that someone has who has Prader-Willi syndrome. But of course, if they develop a mental illness over and above their Prader-Willi syndrome, that is going to impact their ability to understand the nature of a decision, to be able to balance things and arrive at a choice. And for those of you who've supported someone with Prader-Willi syndrome who has developed a mental illness, you'll realize that during that time, it would be really very difficult for the person to engage with the decision-making process. And this is just from very early work by Sarita Soni with us that shows that it's more common among the psychotic illness people with the UPD. Now, it's also very important, and this is not directly relevant to this talk, but always to emphasize here that psychotic illness actually is very treatable. The issue is to recognize it and then to treat it. And of course, if someone is mentally ill over and above their Prader-Willi syndrome, at times different legislation comes into play, such as the Mental Health Act rather than the Mental Capacity Act. I want to now, if you like, take a step back and go back to the issues of cognitive function and social development, because I think this is important. We tend, I think, certainly within the field of learning disabilities, pay a lot of attention to issues around IQ. And as you will know, in the general population, the IQ falls around 100. And if you look at the mean IQ is around 100. If you look at the population of people with Prader-Willi syndrome, usually what you find is it's 40 points below. So it's about 60. But of course, within the population, there will be those people who are much more able from an intellectual point of view, and there'll be those people that are less able. And some of those will not meet strict criteria for having a learning disability. In other words, they'll have an IQ above 70. Now, I sometimes think we place too much emphasis on this. I think when it comes to understanding some of the behaviors, but also understanding issues of capacity to make decisions, some of these, as I call them, higher order problems may be more important. So executive function, this is the ability to plan. The ability, in a way, it's really to make decisions in a broader context, both drawing upon past experiences as well as the present context. The ability, for example, to recognize emotional expressions or recognize the thoughts and feelings of others. The ability to retain information for long enough to be able to make that decision. Perhaps a tendency to very concrete thinking, having a poor concept of time. All these things will subtly impact on someone's ability to arrive at an accurate understanding of the issues that are relevant at the particular time. Now, I won't go into the rest of the slide because of time, but I want to, in a way, end this first part of the talk by really trying to pull all this together. And we're doing this as part of an initiative set up by the International Prader-Willi Syndrome Organization to look at mental health and behavior in much more detail. I think as Susan and others and Patsy will tell you, I think behavior and mental health issues are one of the commonest reasons why families contact the association. And the same is true with the International Prader-Willi Syndrome Organization. So we felt very strongly we needed to do something about it. And I think the way to think about it, you can see the sort of brain behind all of this, is that, of course, the brain is the decision-making organ of the body, and it's receiving information from our senses of the external world, but it's also receiving information from about the internal state of the body. So fullness and so on, temperature, all those sorts of things, pain. And then it responds accordingly. And there's some very interesting theories now about how the brain establishes a model of both the internal world, the body, as well as the external world. And it keeps updating these models from minute to minute and hour to hour. And I think one of the ways of thinking about the challenges for someone with Prader-Willi syndrome is that this these models they have in their brain, if you like, and a model isn't quite the right word, but I think you'll know what I mean, are both inaccurate but also incomplete, because cognitively they're much less able to understand and make sense of the external world. For example, interpret the feelings of other people, which is a necessary part of understanding the social world. But also, of course, the information that they're getting from their bodies may be interpreted incorrectly. So it may be that they feel they are still hungry when in fact they are full. And the way to think about this is really the challenge for someone with Prader-Willi syndrome is to respond to the changing demands that come for all of us in the physical and social environments, and just how difficult that can be for people with Prader-Willi syndrome. So if you have that picture in your head, I think you can see why decision making and then acting in accordance with what you would wish in your values can be very problematic, because of not having, in a way, a complete understanding of the world and of your own feelings and bodily experiences. So I thought, for me, we might just pause briefly, and you may or may not have comments, but I'd be really interested in your thoughts about this, because I know in those of you attending today, there are people with a lot of experience, whether it's family members or paid carers, a lot of experience supporting people with Prader-Willi syndrome. So the question here is, what is the likely impact of the cognitive and neuropsychiatric phenotype, so the characteristics of Prader-Willi syndrome, on decision-making capacity and on the ability with a person with Prader-Willi syndrome to act in accordance with their values, their will and preferences, which is the phrase often used here, and act in their best interests? And how can we maximize their strengths and help minimize their, if you like, their cognitive weaknesses? And I just would pause, and I don't know whether I should unshare just briefly.
I'm just going to ask a question from Christopher Lack, who's from a residential service. He's asking, it would appear a lot of local authorities have a very limited knowledge of PWS and how capacity can be affected, particularly relating to food security.
Yeah.
Could you offer any advice, Tony, on how local authorities can access this kind of information? Obviously, they can, we have some information, certainly, but as a residential service, they're saying that they struggle with this. Yeah. And then the incorrect type of support is commissioned.
Yeah. Yeah. I think that's an absolutely crucial question. And I suppose the truth is, I don't know if we have the full answer to that, if you like. I mean, I do think, first of all, you as an association having information and being able to make the case is important. I think one of the dilemmas is that where the discussion is between the care organisation and, say, the social worker, is that sometimes if there isn't trust between those two groups of people, the social worker can misinterpret that the care organisation is really making this case in order to get more resources or whatever, when actually they're making a case for very good reasons. I think the other issue is that we are, and in a way this is a positive thing, we are of course now working at a time when there is a great emphasis on rights and freedoms and choices, as set out in the United Nations Convention on the Rights of Persons with Disabilities. And I think the message that we need to be much more subtle about is how, in the case of people with Prader-Willi syndrome, some restrictions appropriately planned and appropriately given or organized, if you like, can actually free people with Prader-Willi syndrome up and make it easier for them to then engage in life, because they're not constantly, if it's around food, they're not constantly preoccupied with eating. But secondly, of course, they remain physically well. Once someone starts overeating and becomes extremely obese, the quality of life just goes down and down and down. And, they can't move properly, they're feeling physically unwell, they've got diabetes and so on and so forth. And we've got to constantly say, we're not doing this because we want to impose our views upon them. We're doing it because we know that by doing it, life will be much better for someone with Prader-Willi syndrome. And we've got to collect the data for that. We've got to be able to demonstrate that. And I think that's where the argument rests in a way.
So that's a really good answer, Tony. Thank you. And Christopher, we do have some information that we can send out in case studies that may be helpful. But I hope that answered your question. Feel free to email me, Christopher. I'll ask Lizzie to put my email address into the chat box, if that's okay, Lizzie. If we don't have any more questions around this kind of point, are you happy to continue, Tony?
Yes, I mean, certainly. And we may want to revisit some of these points, because some of them I think I cover a bit as we move along. But just to sort of emphasize that I think it's really important for all of you to think about that someone may have impaired capacity for really quite subtle reasons. These cognitive impairments that I refer to as higher order cognitive may not be obvious. And so it can be difficult to bring them out in a way, and to recognize that they are impairing someone's ability to make decisions. Of course, that will depend upon the complexity of the decision. If the decision is relatively easy, that's one thing. But if it's a complex decision about perhaps where to live and so on, then these more subtle impairments can really impact on a person's understanding. So I want to sort of now follow this through by focusing a little more on the issue of capacity and the Mental Capacity Act, and argue that the Mental Capacity Act is really a legal framework for support and for balancing. It's the sort of way it provides the framework whereby people can try and balance what I've called here competing priorities and for managing risk. But we think of capacity very much in terms of the Mental Capacity Act. But I want to take, again, a step back a bit and say, if we think about our own lives and we think about how we manage the demands that come from a day-to-day, month-to-month, year-to-year basis, there are different aspects to capacity and to what one might also call competence. You know, there's this ability of what's called self-determination, pursuit of your own interests in line with your values. So you say, whether it's a hobby or it's the way you want to lead your life or whatever, it's the ability to organize yourself and to make those decisions that are in line with these wishes and your future wishes. But there's also this ability to avoid doing things that are contrary to your interests and to your values. So one again can think about someone with Prader-Willi syndrome. They may say to you, I want to lead a healthy life. I want to be able to go out and walk around and take exercise. I want to be able to wear nice clothes and so on. But actually what they're unable to do is to pursue that in a way and to control the problems that they are faced with in terms of, for example, their eating or their behavior in general, in a way that is consistent with these wishes. And then there's this issue of self-protection, the ability to avoid undue influence or influence from the values and the interests of others. And, you know, at a very simple level, you could see that through the danger of going along with something that you really didn't want to do simply through, say, the offer of food, or because you don't actually quite understand what it is that is being asked of you. And so I think it's quite useful to think about these importance of self-determination, of self-legislation and self-protection. Now, all of these, in a sense, are complex psychological phenomena, if you like, and they're not in themselves indicative of capacity or mental capacity as defined in the Mental Capacity Act. And I think the way we need to think about it is, if you look at the population generally, or the population of people with Prader-Willi syndrome, there's this sort of broad concept of capacity that I've just talked about, that in a way is relevant to all of us. And if that in some way is impaired, it may not amount to being defined as lacking capacity, but it may make you vulnerable. But of course, consent remains the key issue here. That for someone who is considered to have capacity, although that capacity may in some way be wanting, that they may be vulnerable, but consent is really important. And one should never forget that, of course, the way most things happen in life are through either, consent or implicit or implied consent of one form or another. It's only in terms of the Mental Capacity Act where the question of whether someone's broad concept of capacity is so impaired that they don't meet what's called the legal definition of capacity, and I'll come back to that in a moment. And of course, the Mental Capacity Act requires that in order to be defined as lacking capacity, you must start by saying or recognizing that someone has an impairment of or disturbance in the functioning of the mind or brain, and that impacts on someone's decision-making capacity. And the other point to make is around this rather artificial line that's been determined by legislation, the definition of capacity. Someone will drift either sides. It's not fixed, and I'll come back to that. It's a judgment that has to be made, and it's a judgment that you can disagree with. And then finally, of course, you may decide that someone lacks decision-making capacity, that you need to act in their best interest, and I'll come back to all of this. There's the question of what is possible in practice. And I can remember seeing someone with Prader-Willi syndrome who used to rush out of the house and then would disappear for a while. And the question is, what do we do about it? And if you try to lock the front door and you try to contain the person, then they would up the ante in terms of their behavior, and aggression would be a problem. And you sometimes find yourself that you would like to do this. You think you could legally do it, but if you do it, there's a problem. It doesn't sort of work. And again, we might come back to this. And I would be very interested to hear from those of you who are, particularly those social care providers, whether you find this is the case. There are situations that you feel are justified and appropriate and would bring benefit, but actually in practice, it's really difficult to do. But I do just want to get back to this issue of consent, because, if you have someone with Prader-Willi syndrome, and if they agree to living in an environment where access to food is controlled, that is wonderful. And, in general, you really want to be able to work with people and support people with Prader-Willi syndrome with their consent. And their consent, a valid consent in law, requires that someone is properly informed about the issues, so say about food restriction. They understand that, so they have capacity, and that they're agreeing to that voluntarily without being coerced. And of course, there are going to be a number of factors in their life, both past and present, that will impact on that. So have they had opportunities to understand what the options might be? Do they understand, or have they, what's been the nature and type of support that they've had in the past? Have they had choices, and have they been able to make choices, and so on? And again, issues of reasonable adjustment. Some of these we'll come back to. But there's a danger that one rushes to the Mental Capacity Act when actually your first issue is, when you're working with someone with Prader-Willi syndrome, or someone, say, with an intellectual disability more generally, can you work with them in a way that they feel informed, that they understand what it is that you're asking, and that they acknowledge that that is in their best interest and therefore are consenting to it? Because if you can do that, then things are going to be generally much easier. But of course, we know that that doesn't always work. And that's when, of course, legislation and the law starts becoming relevant. So the Mental Capacity Act was really developed, and this is just briefly, and many of you will be very familiar with this, because there were a number of cases here, F and C and MB, in which these were people who there were decisions to be made that clearly were very significant in their life, and there were disagreements. I mean, this MB is a very interesting one. There was a lady, nothing to do with Prader-Willi syndrome, nothing to do with intellectual disability, who was pregnant and was advised to have an emergency cesarean section and refused. And the reason she refused was because of a phobia of needles. She couldn't bear the thought that she would have a drip in place. Yet the risk to her child was very high. And an urgent meeting of the court ruled that the doctors could do an emergency cesarean section without her consent, because her capacity was so impacted upon by her fear of needles. And she, of course, was very pleased in the end because she had a healthy baby that was born. But this was all case law at the time. So the Mental Capacity Act was developed to set out in law the circumstances when an adult can lawfully act on behalf of another adult without his or her consent, whether this is in terms of healthcare or whatever, particularly where not to act leaves the person open to either neglect, exploitation, or abuse, or ill health. So it set out the processes and criteria to be applied when you make judgments about capacity, and then when you make a decision on behalf of the person judged to have to be unable to make that decision for themselves. And the Mental Capacity Act was therefore both a statute, it was an act of Parliament that set out how you define decision-making capacity, how you define best interests. But importantly, the Mental Capacity Act was also a culture change. It was really about, much more about saying to those providing care, you need to engage with the person. You need to respect choices, but you also need to know when when those choices may be made by someone who is lacking capacity. And it also really was, it went beyond into the community and was talking about the vulnerable adult. It was also talking about this issue too of your responsibilities towards people who may have capacity but are vulnerable in the way that I described before. It was amended because of issues of deprivation of liberty safeguards, which I'll come to. And there's a further amendment to come into law. I think it's April 2022, in terms of changing what's known as the deprivation of liberty safeguards into what's known as the liberty protection safeguards, and bringing them more in line with the Care Act. So, as I mentioned earlier, in order to say that a person lacks capacity in relation to a particular issue, he has to have an impairment of or disturbance in the functioning of the mind or brain. And one of the questions that has arisen is this the case for people with Prader-Willi syndrome? And I think it's really important to say we know increasingly that people with Prader-Willi syndrome do have an atypical history in terms of, or atypical brain development that is indicated by their delayed and often atypical developmental history, by findings on cognitive assessments, but also increasingly there have been studies that have used brain scanning to look at the pattern of brain development that occurs, but evidence of developmental delay in childhood. And here I've talked about homeostasis, the ability to respond to changes in the environment appropriately, and the role of the hypothalamus. Again, it's very important that we sort of recognize that people with Prader-Willi syndrome have real problems in regulating their behavior, whether it's their eating behavior or their behavior in terms of responding to change. And that's largely because of problems in terms of the way the hypothalamus is developed and its connections. I've mentioned the higher order cognitive problems that they have, and they may also have more obvious functional abilities, functional impairments. And I mentioned the IQ. The point about it is if someone says to you, well, how do we know that someone with Prader-Willi syndrome meets this requirement of an impairment of or disturbance in the functioning of the mind or brain, particularly where they have an IQ that is perhaps above 70, so are not technically defined as having an intellectual disability, then I think evidence from that person's developmental history, evidence from how they've responded to change in the environment, evidence from assessments of their cognition and so on, are all very important because they confirm that really someone with Prader-Willi syndrome does meet this criteria. But of course, the decision about whether someone lacks capacity depends upon, is decision specific and time specific. It's about being unable to understand the relevant information, to retain that information, and then to use it and weigh it up to arrive at the decision, and then to communicate a choice. So these are the issues that have to be considered. And we'll come back to this in the third section of the talk when we look at the Mental Capacity Act within the context of social care. So really, in a sense, to bring this second session to a close, if you like, the issues in terms of assessing someone's decision-making capacity that you have to look at, the issues you have to ask yourself is, first of all, if decision-making capacity is decision-specific, and it's accepted that someone may have the capacity to make some decisions but not others, you have to say, well, what is the decision in question here? Is it about accepting the need for a care environment where access to food is controlled? Or is it something rather different than that? Is it about money, for example? Having decided that, what is it that the person needs to understand, needs to be able to weigh up, etc., in order to make that decision and then to communicate their choice? But I think there is a more complex issue, and that's about the threshold of understanding that someone needs to have and should be achieved. And to some extent, that depends upon the seriousness of the decision. So if someone with Prader-Willi syndrome has, for example, decided they wanted to live in an environment where they have free access to food, and then they're now very obese and their health is seriously at risk, and perhaps their life, that's an extremely serious decision. And the threshold that they need to reach in order to be considered to understand is going to have to be necessarily higher than if the decision is about what food, about what clothes to wear, for example. And of course, there are ways that you need to present that information that makes it easier for people to understand. And then you're going to ask that person to recall that information in order to determine whether they have understood it. And I think you should think about decision-making capacity as a process, that there may be circumstances where you're uncertain and you give the person the benefit of the doubt and say, okay, well, let's accept you do understand the risks here. In a sense, let's see what happens. And someone's capacity is going to be very much an interaction between their abilities and the demands of the decision-making task. And that may be influenced by the circumstances at the time. So I think you should think about mental capacity, in the context of the law. Decision-making capacity is crucial because it determines whether you can override someone in terms of the decision they are making. And of course, in the law, just like you can't be a little bit guilty or a little bit not guilty, you're either guilty or not guilty. In law, capacity has to be seen as black or white, but in reality, it's grey, or it may be grey. There may be circumstances where it's very obvious someone lacks capacity, but there are often circumstances where it's difficult. That the capacity as defined in the Act doesn't really model how we make decisions. Rather, it asks, does an impairment or disturbance in this person's functioning of their mind or brain affect their abilities to make this particular decision, to understand it, to retain the information, to weigh it up, to communicate a choice? And then it's issues around best interests that I think really relate to the judgments that have to be made about value. And if someone is considered to lack their decision-making capacity, then others, the decision maker, and we'll come to who the decision maker is later, can act can make that decision on that person's behalf. But they have to bear in mind that person's values and beliefs, their past wishes, their present ascertainable wishes, the views of families, the pros and cons of the various options available. And the point to make here is that these are judgments, not certainties, and therefore must be open to challenge and should be able to be justified by those who determine them. So I would say to those of you particularly who are social care providers, when you arrive at a decision about that someone lacks capacity, then you need to be able to say, well, if someone said to me, why did I decide that? What would I say? And I think it's really important to be prepared to defend your position, because this is a legal, in a sense, it's a decision that you make that is fundamental to human rights. Then I think best interest in the Mental Capacity Act is really trying to get this balance between allowing some level of autonomy and paternalism, or parentalism as I've called it here, and enables some level of choice. It's a difficult balance, but a decision maker must always act in the person's best interest, considering what may at times be conflicting rights: the right to life, the right not to be subject to cruel and inhumane treatment, the right to a private life. So, you may say, this person lacks capacity, we need to control access to food, which may be seen to be a challenge to their private life and their right to make decisions for themselves, but it's protecting their right to life. So these things may be at times conflicting. And I think what you're doing is, if, for example, if you've got the absence of food security and life-threatening weight gain, or someone's leaving the house and putting themselves at risk, what you have to do is step back and say, what do we need to do here? What is legal? So what can we do in law? But also what is justifiable and acceptable, and what is possible? And these things are very challenging. And it's only often through discussion and sharing ideas that one can really arrive at an answer that is both legal and justifiable and brings real benefit and is in someone's best interests. So, and some of these issues we'll pick up in the final part of the talk. But what I would say is, given the law as set out in the Mental Capacity Act and the Code of Practice, what particular problems would you anticipate, or perhaps have you experienced when implementing the Mental Capacity Act in the context of supporting someone with Prader-Willi syndrome? So, Patty, to give everyone a little bit of a break and stop listening to me going on for a while, again, have people got questions or their own experiences that they'd like to share, and then come back to it.
Perfect. So I want to invite Ruth in, but she's made quite a good point. I'd like to invite Ruth in just to kind of have a quick chat with you and ask a quick question, and then I do have a question in the box as well that I'd like to ask afterwards. Ruth, over to you, my love.
Thank you. Hello, Tony.
Hi, Ruth.
Hi.
Nice to speak to you.
I just wanted to make a statement, really. It's partly a question. In terms of doing the assessments, they're only as good as the person who's carrying them out. And if they don't have enough knowledge, or perhaps they haven't had enough training, things can go wrong, because very often I'm thinking of a particular circumstance where I was told by a social worker that she had carried out an assessment, and the question she had asked this lady was, if there were 3 cakes in the fridge and you were only allowed to eat 1, what would you do? And the lady with the Prader-Willi syndrome had said, well, of course I'd only eat 1.
Right.
And so that was, then she was deemed to have capacity, despite the fact that, this woman is, we think, accepting food in return for other things. And it's a really difficult situation. So if the person really hasn't got any experience of Prader-Willi syndrome, the person that's doing the assessment, it's very hard for them to understand that hyperphagia and that need for food and that desire for food all the time.
Absolutely. But I think, in a way, and I would say this particularly to people who are working in the social care sector and supporting people with Prader-Willi syndrome, I think they and all of us need to get much better at being able to give the information that, in a sense, tells the story that you need to tell in these circumstances. And I'll come to this in the third part of the talk a bit more. But part of it, and this came up in case law, and James Coding in his article he's written about this has said this, is that we need to be able to, we have to be careful not to say, well, because you have Prader-Willi syndrome, this is how it's going to be, and therefore you lack capacity. Rather, we need to be able to say, to some extent, on the basis of your answers to questions, but also on the basis of past experience, what do we know about this person that might help us make a sensible decision about their capacity? So, if someone has repeatedly said this and have repeatedly demonstrated that they can't then act in accordance with that, and that they've never learnt that actually when faced with 3 cakes, they will eat the 3 cakes, and that, you know, then you know, if we got that evidence, then you have a much stronger case to say yes, you know, and even if, you know, you're preparing a report for a court about this or whatever, you can say that so and so said to me that this is, she'd only eat 1 cake, but what experience has shown in the past is that when faced with this situation, this is how she behaves. And that's why, you know, we tend to think of assessing capacity as a sort of one-off thing. You're asking questions in the here and now. You need to relate it also to how someone acts when faced with that situation, if you have that information.
Thank you. That's really useful. Thank
It
you.
is incredibly useful. Thank you, Tony. And I think one of the things that we're doing as an association is that we are putting together packs, kind of information packs, support packs is what we're calling them, for support workers and for care workers. And I think it'd be really prudent if we include that information in there as well, so that it kind of reiterates that it's a decision by decision, but to use information anecdotally as well is perfectly acceptable.
Because I think, Patty, I think one of the dilemmas is, you know, and to some extent, I think this one can criticize the Mental Capacity Act here a bit, that it's very much on how you assess, you know, it's set down how you assess it, but it says very little about whether how you act is in line with what you said you would do.
Yes,
That's the disconnect for people with Prader-Willi syndrome so often.
Yeah, absolutely. So we will make sure that we add that. I have got I've got a question in the box that I'd like to ask you, and then I have got a raised hand, if that's okay.
Yeah.
Yep. Okay. So again, from the same residential setting, a gentleman's asking regarding consent. They have a number of individuals that live with them that are deemed to have capacity and consent, and they do give consent to the care and support that they provide. Yeah. They then struggle once an individual withdraws their consent, but they're still deemed to have capacity. Right. This can then drastically affect the way someone's supported, again, practically around food security. Yeah. This particular setting can find it a struggle when they can verbalise the correct answers, which we may have just gone over actually, where they can verbalise the correct answers, but they can't put it into action, which is exactly what you were just saying about the example of the cakes. Is there any information available in that regard? Are there any case studies or any studies around that, so that they can so safely and appropriately support them to continue with a healthy life and make their own choices?
Right. That's a really important question, and again, I think a very familiar scenario. If
absolutely.
Like. I mean, I think one thing, and I say this sort of carefully, but is I think the danger, to some extent, of course, we shouldn't shy away from perhaps allowing someone to test something out if they haven't had that opportunity in the past.
Yeah.
You know, because to some extent, what we are trying to do is to help someone with Prader-Willi syndrome learn themselves about their struggles they have through no fault of their own. That's the nature of being born with Prader-Willi syndrome in a way. So, but where I think the fault lies is if you say, okay, well, you have capacity, you've made this choice, we disagree, it's up to you now, and you sort of walk away.
Yes.
That's wrong.
Yes.
Seriously wrong, in my view. So if you're going to say, okay, well, you know, George or whoever it is, you've said to us you want to have more control over your thing, and you're insisting that you do that. We have some concerns about this, but let's try it and let's see what happens. But there's a point at which you might want to try, and then obviously you might need to pull that back. Now then the question is, and there is a court case that I will illustrate later, that basically says you need to keep this under review. Now the dilemma here is when someone starts overeating, is that an unwise decision?
Yep.
And if it's an unwise decision, that by itself is not enough to say someone lacks capacity. We all make unwise decisions. Or is it that they now really don't have capacity, and you therefore need to invoke, if you like, the Mental Capacity Act, and that will give you the power to bring things under control again. And if I may, I'll come back to that in the third.
Absolutely, because I think it is a really important question, and I think it's it's difficult for residential settings in exactly as you say, because if you are going to give someone the opportunity to learn from it, it has to be done safely.
Yeah.
And not just in a way of, right, you have capacity, so we're just going to leave you to it. And if you continue to eat, you continue to eat, because we can't do anything.
Yeah.
Because you can do something. And but it's making sure that it's done in a very safe way and that it is reviewed, but that there is, to an extent, there is a level of choice and a level of independence to see if there are lessons that can be learned and to see that if it is something that can be achieved, but certainly not a, oh, well, they've got capacity, so we can't stop them.
No, that's right.
Which is not the right attitude to have. I would like to invite, or certainly that's my opinion, that it isn't the right attitude to have.
Absolutely.
I'd like to invite Laura Sabawal to come in, my love. I'm going to give you permission to talk if you'd like to ask your question. I do have another 3 questions in the answer box that I'd like to be able to answer before we move on, if that's okay. So Laura, over to you.
Hi, it's actually Arvind.
Oh, I'm so sorry. You're not Laura at all.
Arvind, hi. Nice to hear from you.
Nice to hear you, and really interesting, very, very interesting talk. So just a really quick one. So in terms of this sort of mental capacity and then being able to make decisions, what it reminded me of was almost the sort of power of attorney that many of us have faced, those of us in the sort of sandwich generation of looking after elderly parents. So, do you think there comes a point where we might need something like this for our children, that you sort of take over, all of their, not just sort of these sort of health issues and making those decisions for them? Is it akin to that?
Well, yeah, I mean, you raised a really interesting issue in terms of the way other countries have gone about this, and that when the Mental Health Capacity Act was being considered, there was this sort of tension, if you like, between those, and there was a pre-legislative scrutiny committee that examined the draft Mental Capacity Act, and there was a tension. Those who came to give evidence from some organisations that said we need a equivalent of some sort of guardianship power, and then there were others that would say no, people have the right to make their own decision, and the Mental Capacity Act had to sort of negotiate that space a bit. And by and large, it moved away from the idea that you should be able to take over complete control of someone's life. Now, there are some exceptions to that, and they'll come to that. But by and large, they said that where people could make decisions themselves, they should be allowed to. It was only where they lack capacity that others might need to make that decision for themselves. And that's the fundamental principle behind the Mental Capacity Act. It's decision specific. So, the example that's often given is giving someone the right to choose what clothes they might want to wear, and if they want to wear something that maybe not quite right for the occasion, well, so be it. But if they were making a decision about something very serious about their health, then if they really didn't understand that, then you would have, and they lack capacity, you would have the power to make those decisions for them, or the doctor in the case of health would. Now, you and I can appoint someone as it's called a donee of a lasting power of attorney, that if we were to say develop dementia or have a bad traffic accident and lose capacity because of that, those people could then, that person we've appointed or those people we've appointed would then have the power to make decisions on our behalf. Now, the issue for someone with Prader-Willi syndrome is, would they have the capacity to appoint, say, you as the father? Would they have capacity to appoint you as a lasting power of attorney? And that, because you have to have the capacity to do that.
To make the decision.
So that's one issue. The other thing is the court can appoint a deputy. That's usually for very specific issues. So say someone with Prader-Willi syndrome, their parents died and they inherited the estate, which happened to be a lot of money. Then a court might decide that the person lacks the capacity on the evidence they've received to manage that money, and they would appoint a deputy to manage that money on behalf of that person, perhaps knowing that if they had free access to the money, then they would spend it on food or whatever it is. Sure. So those are the circumstances. I hope that sort of answers your question.
No, it does. It does. Helpful. That's very helpful. Thank you.
Thank you very much. Tony, I have had a quick look at the questions that we've got in the box. I do believe that they may be covered in the third part of your talk. So are you happy to continue? If we don't cover them, just having a look, and obviously I can see what's coming up. So if we don't cover them, I will ask you the questions if that's all right. But I'm pretty sure we're going to answer most of them in your next section. So are you happy to continue?
Certainly.
Perfect. Thank you very much.
So here really it is more about putting the Mental Capacity Act into practice. One particular, who makes decisions, when and how. But I am also going to cover this issue of briefly this issue of deprivation of liberty, because it is quite a crucial issue. But as I sort of said earlier, that I think one of the key principles here is when you're thinking about using the Mental Capacity Act and you're putting it into practice, I want to remind you that things are really definite. They're really black and white here. You are having to make judgments. So you need to be careful and think about the evidence that you've called upon in order to arrive at those judgments. So a judgment that someone lacks capacity, and a judgment about if they lose capacity, if they've lost capacity, what's in their best interests. And the legal criteria here is that on the balance of probability, you believe that this person at this point in time lacks the capacity to make this decision. And on the balance of probability, you believe that the following is in their best interest. So that's the sort of the technical aspects of it all. Now, there are what I've called here dilemmas or tensions, if you like. One is, and I'll come back to this in a moment, but that is that under the Mental Capacity Act, if someone lacks capacity, you can, if it's in their best interest, place some restrictions on their life. So restricting their access to food, for example. But if those restrictions amount to what's called a deprivation of liberty, that cannot be covered solely by the Mental Capacity Act. That's when the deprivation of liberty safeguards come in. And that's because of a well-known case, what I've called here the Bournewood case, and because of case law. And I will touch on that. I think there has been case law around the nature and extent of the decision in question. And here an example might be is that you might be asked, and that sometimes when it's come to the Court of Protection, I've been asked to say, does the person have capacity to decide about their care and have the capacity to decide about where to live? And the reality is that they're essentially two of the same thing. Or if someone was advised to have treatment, quite extensive treatment for, say, cancer or something, it's no good saying, well, they have capacity to decide on this, but actually not on that. It's about, do they have capacity to decide on the totality of the treatment that is required? So there are interesting issues that have to some extent been covered in case law about how narrow the issue of capacity is around a particular decision, or how broad it might be around care and where to live, for example, or a treatment program for a particular condition. But also it may be limited to capacity in the context of an outburst. So it might actually be very limited. So what right do you have to interfere with someone, restrain them? And that may not be the right thing to do, but do you have a right to restrain someone, to protect them from harm when they're having an outburst, when previously they've said they don't want you to do that, for example? Then there's the question of who makes the decision, and I'll come to that. There's the tension that we've already discussed a little bit between whether something is an unwise decision or an incapacitous decision. And there's this issue is what is legal and what is possible, which I think is sort of quite an important issue at times. But
sorry, Tony, could I just interrupt quickly, just because I know one of the questions is really relevant to what you were just saying. From Jeremy Ireland, the residential setting that their son is in doesn't use any manual holds. A DOLS has been put in place to have this put in place for their son, and it's something that their son has requested themselves. Right. And so Jeremy Ireland was just asking if you have any kind of thoughts around that. I just thought it was an opportune time to ask, because if you're just saying, you know, if that person doesn't want it, what happens if that person does want it?
Right. Well, doesn't want dolls, you mean, or does
So
want
the
dolls?
dolls is being put in place for something that he has requested himself. He's requested that they use manual holds, but it isn't a practice that the residential setting use at the moment.
Yeah, I mean, I think that's a really interesting thing, and I think that that actually shows that, of course, and this is something that I think we've talked, Patsy, you and I think have talked about this before. You know, when someone has an outburst, that's not the time to have a detailed discussion with them. By and large, as all of you will know, this is the time, if you can safely, you basically want to withdraw and just let things calm. But we're always saying afterwards, the next day, or when someone's completely calm, you might well want to say, well, how could we have handled this differently, or what could we have done instead? And I think there, if someone is saying, what would help me is this, then that's very worthwhile listening to. Now, it may be that in practice you try it and it doesn't work out. But first thing is, you would record that. I think, you know, in the residential setting, it would be very important to record the discussion that you've had. So if someone ever questioned you, CQC or whatever, questioned in the future why you did what you did, you would say, well, this came out of, you know, of careful and thoughtful discussion with the person themselves. It's a bit similar to the fact that often, I think now increasingly, you see people with Prader-Willi syndrome that say, I want you to limit access to food, because that way they feel safe. Now, it may well be that someone who, when out of control, is nervous about they might harm themselves, or they might harm a loved one, or a care worker, or whatever, that they feel safer knowing that this is what's going to happen, partly because it's predictable to them, even in the context of an outburst. This is what we have agreed we would do. Partly it also helps the staff because they know what to do. Partly
Absolutely.
it makes the person feel contained and safe.
Thank you very much, Tony. Please carry on. I just thought it was the best time to ask it.
No, I think that's a really nice example. I mean, it's really nice to hear these examples, because I think they're so instructive. I mean, just put this rather general slide up to say that I think, you know, all these things must be seen within a broader context. You know, I mean, we do have, very importantly, the political and policy frameworks that are perhaps best captured by the United Nations Convention on the Rights of Persons with Disability, but also by things like valuing people and that sort of thing. And we have case law that develops. So these are cases that have gone to the Court of Protection because there's been disagreement about what should happen, and the Court of Protection has ruled that this is the way you should deal with this situation. We have the fact that someone may be in residential care or they may be in supported living. We have the issue that there may be in circumstances where there are good resources or poor resources, say in terms of staff. We may be talking about what I've called here strategic decisions. You know, they're going to have an investigation in hospital, so that's some way off, or they may need to move house or whatever. And you'd like more immediate or day-to-day decisions, opportunities of whether they have opportunities of choice, and so on and so forth. So issues of liberty, what's often referred to as issues of authenticity, the real experience of people with Prader-Willi syndrome, and issues of capacity. All these things are occurring within this framework. And I show you this slide because this was someone who did a PhD with us, not about Prader-Willi syndrome, but I thought this was really interesting and insightful. And here you could be a person with Prader-Willi syndrome is variably an agent, to use, if you like, technical terms, to be viewed as someone independent and able to make choices, as someone who's vulnerable and to be safeguarded against risk, or someone who's frightening to be kept from harming others. And all of those who work in social care, and those of you who are family may well have experienced this. There are times you think, we need to help our son or daughter or this person we care for to make choices, but we need to protect them. And other times, I'm scared, they're having an outburst and I don't know what to do, or they might hurt me, or they might hurt themselves. And of course, those of you in social care are having to juggle these things because these experiences are happening on a day-to-day basis. And I think it's quite nice, you know, when we're at a time with the serious problems in social care in terms of recruitment and career opportunities and things, that these are really difficult issues that people with Prader-Willi syndrome will, in a sense, illustrate that perhaps more than any group of people who may or may not have intellectual disabilities. Now, one question I was asked to particularly look at is this question of who decides. So someone is considered to lack capacity. There is a decision that now has to be made about treatment for some health condition or where to live or something like food restriction or whatever. And of course, the answer is that the person who decides is the person who requires the decision to be made. Now, it's easy to say that, but it actually gets a bit more complicated than that. But in terms of day-to-day decisions, that is really going to be you as support staff or you as family. And the situation then may arise that there is a disagreement about that. And then that you're moving on to the issue, do I think that the person really understands and has capacity to make this decision for themselves? Because if I don't, I can act in their best interests. It may be a social worker who is having to make recommendations about where someone might live, and we've come back to that example that someone gave earlier, and the social worker there is having to decide whether that person lives in a Prader-Willi specific environment or not. Or it may be a health worker, because someone has come to see me as a doctor, I'm recommending a particular treatment. Whether or not that person takes that treatment will be dependent on them consenting to it. But if they lack capacity, then I can suggest that they have that treatment, whether or not they're consenting because they lack capacity, providing it's in their best interests to have that treatment. So it's a bit complicated, but I think these are the general principles. It can be elevated or go up. So you can, as I mentioned to Arvind's question earlier, someone who's been appointed by that individual to be their lasting power of attorney. Once that person lacks capacity, then the LPA, the donee of the LPA, can make decisions, or a court, the court of protection, court can appoint a deputy to make decisions for that person, or it can go to the court, who then rules individually about something. And I think one of the issues that I sometimes find myself faced with is I'm asked to see someone by the Court of Protection to give an independent opinion. And you look at the circumstances, and the situation has deteriorated dramatically over perhaps some months. And you think, why didn't people think about the Court of Protection earlier? Now, there are issues about the Court of Protection, and the general principle is you try and resolve these things before you go to the Court of Protection. But the Court of Protection is the final arbiter where there are disagreements about what should be done, or disagreements about whether someone does or does not have capacity, or what is or what is not in their best interests. So I'm going to move around a bit here, but I think the other issue that I've touched on already is this issue of unwise decisions, because again, this comes up and I get asked about this. An unwise decision, and it's clearly stated in the mental capacity, is not by itself an indication of impaired capacity. If someone says, I want to go rock climbing, you might think, oh, that's a foolish thing to do because you might fall. It's for them to decide. They know the risks and so on. So here, if someone with Prader-Willi syndrome says, I think I now want free access to food, that you might think to yourself, well, that's actually unwise because I know what will happen. But is it incapacitous? Because if it's incapacitous, then you might be able to overrule it. But if it's simply being unwise, then that's a different issue. So, believes that he can diet by his own efforts and therefore wants access to money and control over food. And we're beginning to get sort of information, and I'll in the next few slides go to some court cases that James Coding has sort of identified for us, which I think are really helpful. But what these case law and these court cases are beginning to suggest is, well, of course you have the more direct assessment of the person, him or herself, and you need to look at the views and wishes of that person. But you need to see it within the context of where they're living in their lives, but particularly in terms of the past history. Have they previously coped with independence or not? And if they have, or if they have had episodes of having free access to food, and they managed for at least for a while, well, that's one thing. Or if they've had access to food and it's failed very quickly, but they still believe that they were able to do it in the past, that begins to suggest that they really do not understand and the issues in question, and they may lack capacity. You need to look at present circumstances, and you need to consult and look at the observations made by others and the views of others, such as family and support staff. So if families say to you, yes, we tried this or we tried that, and this is what's happened, this may be very helpful in being able to interpret the views that are being expressed by the person themselves. To what extent can we put weight on the fact that the person with Prader-Willi syndrome is saying to us, yes, I think I can have control over food or whatever that they are saying to us. To what extent does that fit with past experiences and observations made by others? Because that may help us make the case that someone lacks capacity, or it may say to us, well, okay, the circumstances are such that maybe he or she does have capacity to make this decision, but we need to be very careful and we need to watch over time. So this was one particular case, and I remember it because I was the independent advisor here, and I was pulled over the coals by the counsel, by the barrister acting on behalf of the person with Prader-Willi syndrome, saying that I had prejudged the situation based on the diagnosis of Prader-Willi syndrome. And actually, I think he was right. And it was a real important lesson for me. But also in this particular case, the person was very reluctant to talk to me and to others, for that matter, about it. And I had sort of put that down to their Prader-Willi syndrome and their impairment or disturbance of the functioning of the mind or brain. And the court felt that there were other factors that perhaps I should have paid attention to and tried to address before assuming that they weren't talking to me because this was a part of their, if you like, their Prader-Willi syndrome. But importantly, whilst they ruled that the person had capacity, and I haven't heard what's happened since, to make their own decisions about where they live and the care that they have, the court said, should a situation arise where there are complex decisions to be made, it may be necessary to reconsider issues of capacity in light of those decisions. So the court was very clearly saying, if you do think someone with Prader-Willi syndrome has capacity, you need to respect that, but you need to keep an eye on things. And here was some examples. Has the person tried to manage their eating and diet independently before? And if so, what was the outcome? And if they hadn't tried it before, would it be possible, would they accept what here they describe as an initial light touch? So you give them some freedom, but not complete freedom, and so on. And you see what happens. Is there evidence from the person's previous action that they were unable to put into effect the plans that they had said they wanted to and to manage independent? Did they have insight to that? Was there evidence of repeat mismatched statements and previous actions? So they were saying, I can control my access to food, but actually the evidence was that on every occasion they'd had access to food, things had gone wrong, and so on. But if they hadn't had these opportunities, maybe you have to say it's appropriate that we give them some freedom here and see what happens. But you don't stop at that point and say, okay, it's all over to you and we're forgetting about you. You hang in there. Here was a court case that said that basically they argued it was impossible to separate out care and accommodation in this case. It would be artificial and indeed wrong not to consider residence and care together. So in terms of assessing capacity, you had to assess the whole thing. Were they prepared to live in this accommodation where food was restricted and to accept the care package as was? And did they have capacity to understand that? And I think what case law, and again, James has really done all of this, has really begun to identify is what is it that we need to think about when deciding whether someone with Prader-Willi syndrome does have capacity to make particular decisions for themselves. Do they understand the effects of having, do they recognize they have Prader-Willi syndrome? Do they understand the effects of having Prader-Willi syndrome on eating and how you really can't regulate that? That to remain healthy, you needed to actually be able to control your desire to eat and control how much you ate and so on. And I think these sort of guidance is really very important, because what you can do is you can, I think as care staff or as family, you can actually keep records of these observations, and these are going to be very helpful in the future in terms of making, if you have to make some difficult decisions about it. But also, I think what you're seeing with this new generation of people with Prader-Willi syndrome is the opportunity to discuss these things during childhood and perhaps help them learn and develop their skills for later in life. Now, I'm aware of the time, and we do need to finish, I think, fairly soon. The issue of deprivation of liberty is an important one. And I think what I want to do is just to summarize that this issue that the Supreme Court made a judgment about when restrictions of liberty amount to deprivation of liberty. And I mentioned right at the beginning that under the Mental Capacity Act, if someone lacks capacity, if it's in their best interest, you can place restrictions. But if those restrictions amount to a deprivation, then you need to have additional legal safeguards, and that's the deprivation of liberty safeguard. And the point about it is this is what the Supreme Court ruled. And they use this, I think, slightly unfortunate phrase that even though, in a sense, what Lady Justice Hale was implying here is even though you may be living in a wonderful environment, a gilded cage, if you are restricted, it's still a cage. In other words, if you were obliged to live there, if you were subject to constant monitoring, only allowed to go out with close supervision, unable to move away without permission. And for many people with Prader-Willi syndrome, living in a Prader-Willi specific environment, that is the case. And the courts would hold up that they were having their capacity restricted. Now, we might come back to some of these issues in discussion, but I think mental capacity in social care is complex. But one of the things I would say to those of you who work in social care, think about what one might see as more strategic decisions. So do you have a good understanding of someone's understanding of finances, or of their day activities, or of their health? And you need to anticipate strategic decisions so that you can help them gain understanding about it. So if there is going to be the need for a blood test at some point in the future, how can you help the person gain some understanding of it? So when the time comes, they will be happy to agree with it. They will understand what's going on, and so on. I think also helping people prepare for the future is really important, but also having information on someone's beliefs and values. So if they've consistently said to you, I want a life where I can make choices, but I also want to be healthy, I want to look good, I want to wear nice clothes, that's very important, because if they then act in a way or make decisions that are contrary to that, then you can question whether they have capacity, whether they really understand the decisions that they're making. I think probably there isn't time to discuss all of this, but I would ask you just to reflect on your own experience. Is consent to sensible restrictions achievable, if you like? So can we help people with Prader-Willi syndrome consent? Because if they consent and understand what they're consenting to, then that's great. What are the challenges putting the MCA into practice? And how can we help people with Prader-Willi syndrome on some of these issues? And this is James's paper, and I'm unashamedly promoting this book. I want it to reach the sort of J.K. Rowling levels of sales. So, okay. So thank you very much. I'll exit the show. And
thank you very much, Tony. I have got a couple of questions that I wanted to ask you, if that's okay. I am really interested in that book, The Research and Practice, MCA Decision Making Practice. tool. I'm really interested in that. If I could just ask you a couple of questions, I can extend you, I can give you like another 5 or 6 minutes because it's you.
Right.
So someone has asked anonymously, do you know of situations, or even just one example, when recourse to MCA had to be used for someone with PWS, but it was against their will, and what happened next? That's quite a big question. I don't know if that's something.
So when recourse to the Court of Protection was against their will.
The question is phrased as recourse to MCA had to be used,
Right.
and it was against their will.
Yes, I mean, it's actually, I think, probably often the case that it is apparently against their will.
Their will, yeah, I'd agree.
And of course, what it is you're saying is that unfortunately in that situation, their will, that they lack the capacity, if you like, to understand what it is that is being asked of them, and therefore they're making decisions that are very badly informed, and therefore there is, in a sense, a duty to override those decisions. But one of the things to say that if someone objects, then they may have recourse. So, and that's what the Court of Protection is about.
Right,
So
okay.
if you're saying to someone with Prader-Willi syndrome, we think you should live in this type of environment, and they're saying no, and they're living by themselves. And there's a very nice example of this that I was involved with some years ago. She was living by herself. It was getting terribly out of control, became very, very obese. What the Court of Protection argued, and those of you from consensus care will recognize this, they would argue that the person needed to be, she lacked capacity to make decisions about her care. She needed to be in an environment where access to food was controlled, and and the court ordered that she lived in a consensus home for a while, where she did very, very well. But the court, very interestingly, also ordered that she had said that her wish was to live near her family, and her family weren't near a consensus care environment. And the local authority developed a house specifically for her. But of course, that took time. So once the house was ready, she moved from consensus care to that house where it was agreed, and the court said she must live in a food-contained, controlled environment. So, that's the process that you have to go through. You have to be able to make the case that these decisions are incapacitous decisions. We have a responsibility to act in their best interests.
Absolutely. Thank you, Tony.